today's main news story is talking about people getting arrested at the interviews. We're talking about U.S. citizens sponsored children, parents, and spouses at the interview to get the green card, getting detained, locked up for multiple days, and then getting bailed out. Luckily, at least getting bailed out. But I mean, obviously, worst case scenario, detained and deported. It's happening. It started happening last week in San Diego. We already have a log of cases. I spoke at the conference with 2 nonprofit speakers who were saying that within their district in San Diego, this was happening. And then we're seeing this all over the news now. And this is not going to just be limited to sanctuary cities in San Diego. It's going to be spreading across the entire country. And so that is something that we're seeing very, very real. Now, you might be asking, how can this possibly happen? What's the circumstance? It surely doesn't apply to me. Let's talk about it, right? So first of all, what is the basis of people detaining them? Well, according to ICE, these individuals who are going to these interviews, they are visa overstays. Sure, you could say that they're filing for adjustment status. Sure, if everything gets approved, they get a green card. But in the meantime, they are still visa overstays and they can be detained. At first, maybe I was a little bit incredulous. Maybe at first I was giving them benefit of the doubt. At first I was saying, no way. It's just USCIS and ICE registering them. And that's fair because they want to make sure you are not a criminal. You're not just overstaying and using this legal loophole of filing for adjustment of status using 245 to be able to stay in the country. Because we have seen people done it frivolously in the past and they do it over and over again. And every single time they file, they stay here for an extra year, 2 years. They treat it as a quote unquote subscription fee. And now, the moment they go to the interview, they get a notice of intent to appear. Now there's a deportation proceeding, and then ICE just logs them in. I sincerely thought ICE was just logging them because there's no space, there's no facility, there's not enough beds to house all the people who are going, as it is right now, there's already not enough beds. How can you try to detain additional people who are going to these interviews every single day? That's just unreasonable, unfathomable. And yeah, I was wrong. And so we are seeing this now. We're not seeing these in the hundreds or thousands yet. We're seeing just, a handful of these cases. Maybe it is just a political statement. Maybe it is just a deterrent effect. I hope it is, but I'm afraid it is not. And the reason why I'm afraid it is not is because this is something that they're rolling out. This is something that's happening more than just a few instances. And this is not something that they are doing to military spouses as well. They have really strong cases. It's not like, a really suspicious marriage with prior denials and filing for this, and then they detain them for days and registering them. We're talking about strong cases that otherwise would just get a green card, yet they are being detained. And so I'm afraid this is the state of play that we have in the United States right now. If you've entered with a visa, you overstay, you get married to a U.S. citizen, or a U.S. citizen is sponsoring you and petitioning you, your parents, your children, and now you're going to the interview. I am afraid that at that interview, at the very least, you might get a notice of intent to appear. There's now an official court hearing. And then second, ICE might detain you. If they just register you, you pay a bond, you leave, it's just an extra step, an extra check-in. That's maybe the easy way out. But they might detain you for a couple days, do more thorough background search, and then let you out. That's for maybe the standard. And that's something that everybody needs to prepare for. So at least take this as a public service announcement that if you're in this category, you have to prepare for that. And if you're not willing to prepare for that, if there's even a 1% chance that this might happen, and you will not and do not want to do that, then the alternative is going back to your home country and get the green card overseas. I know a lot of people choose not to do that because they don't want to do the consulate process. They don't want to be separated from their spouse. They don't want to leave the country for over half a year, 2 years. They want to be together now. But if that's what you have to face and you potentially might be locked up for a day or 2 or 3, then it might be a better choice. Now, Let's talk a little bit about that, because I think there's a lot of confusion and a lot of stress and a lot of worry and a lot of fear around getting a notice of intent to appear and then being registered by ICE. I want to clarify all that so you know exactly what's happening, so you know what to be afraid about and what not to be afraid about. Getting an NTA, we haven't seen that in the past for people in this situation, but it is not something to be afraid of. The NTA is just another court hearing. If your case gets denied, then you have expedited removal, then you have to leave the country. That is what it should have been doing, but USCIS haven't been doing that. I know people are really scared. I know it's extremely costly, because now you have to deal with the court appearance as well as the immigration petition with USCIS. But it is just that extra step. The NTA doesn't mean you'll be detained, doesn't mean you'll be mistreated. That is not where the fear should be. The fear really is with ICE. Now, again, I know a lot of people who, when they do the ICE registration at these marriage interviews, they register and they're out. Not everybody is being detained for multiple days. It might be a few hours. They're registering you, you're leaving, it's okay, right? But at least they know you're in the data bank. And so if your case gets denied, then they pick you up. That's the idea. Will they eventually enforce that every single person will get detained until they get a green card? Like my assumption in the past, they just don't have enough beds right now to even house that. And yes, they are building more, but is it going to be using it for spouses of U.S. citizens? That seems kind of insane, but it's hard to predict what the future is going to look like 6 months from now, a year from now. But that's the news that I want to share with everybody today, because it just started happening last week in San Diego, and for the next 6 months to a year, that's what we're going to see roll throughout the country. I'll be taking some questions now before we jump into the success story.
Motion to reopen denied. What can I do?
We have done multiple motion to reopens. So one motion to reopen denied, you file a second motion to reopen. It got denied, we filed a third motion to reopen, and then it got approved. Let me kind of explain what the requirements are for motion to reopen. You need to be able to provide documents to show you couldn't have provided it before, and you want to provide it, and you're providing it now, and that with these documents, it would change the outcome of the case. So you can't just provide a random thing that's not related to your case. If you look on our YouTube channel, if you look at motion to reopen, we've done a lot of different types of motion to reopens. The one I was talking about specifically is the clients didn't get the request for evidence, right? USCIS sent a request for evidence, please provide these documents. The client didn't respond, the case was denied. Then they found us, then we filed the motion to reopen. They didn't get it. The school shut down. The RFE was sent to the school. There's no way the clients could have gotten it. Filed the motion to reopen, got denied because they said you didn't provide the requested for evidence. I'm like, well, duh. We filed the second motion to reopen and said, hey, how can we respond to the request for evidence if we never actually got it, right? It's insane. And so the second one was denied, and the client practically gave up and said, well, let's just try it one more time. And we sort of gave up too, because 2 is already a lot. But a third time, we got the attention of the director, and the director said, okay, we'll give you a request for evidence. And then we got the request for evidence, we answered it, and the case was approved. So every motion to reopen is different. Take a really good look at it. Most motion to reopen denials simply state the documents provided should have been provided earlier. We're not going to consider it now. But if you can prove that we did give it earlier, or we couldn't have given it earlier, then you still have a chance to succeed.
My parents just got their I-130 and have a PIP. What's next? They are in the U.S. and I'm military.
Yeah, you got parole in place. Congratulations. They're still doing that. Congrats. And they got I-130 approved, so you are ripe to file for an adjustment of status. For all the key steps, it's just like anybody else, right? So just kind of look through the 45 form, prepare all the documents, fill it out correctly, fill out the payment fee correctly. If you need help, kind of just some guidance, I recommend doing a consultation with Gabby, the Spanish department here at the firm. You can go on our website, it's $250 consultation. They'll walk you through everything. That way you could just do it on your own. And then, of course, if you need our help to do it, happy to do that for you. But if you got your PIP approved, and you got I-130 approved, you're a U.S. citizen, good for you.
Where are you located?
I don't know if you know where Cerritos Artesia is in California. It's right next to Anaheim, Disneyland. And so, if you are, around the area, feel free to swing by and check us out.
Is it worth applying for advanced parole in the current state of DACA?
Yes. But we've been saying this all year, and we still recently have a lot of people who got the advanced parole and then they came into the U.S., so now they're lawfully entered. So definitely recommend still doing it. I am a little bit safer compared to a lot of my other colleagues who literally have told their clients, apply for the advanced parole, go to Mexico and just come back within a single day. I talk to a lot of CBP officers. They really dislike that. So my advice is whatever reason you apply for the advanced parole, right, see your relatives, go actually fly to the hometown, right? If it's for work abroad, go work and then get the pay stubs and then come back. If it's humanitarian, do that, right? Don't just cross the border and come back.
Is it true that marriage-based green card interviews are being placed on hold?
From my knowledge, it's the 19 countries that there's a Trump ban on. But for every other category, it's the exact opposite. We just got a notice today, a client who had their 45 pending since 2023, they just got a second interview. So they're definitely not, pausing interviews.
Is it getting difficult to fix papers for your spouse that entered illegal in the United States?
It is getting more difficult. Waivers are getting harder. So do your absolute best.
Should we go to our interview if we were scheduled one? My husband overstayed, no criminal background.
You should prepare that you might get a notice of intent to appear for a later court hearing. You should prepare that you might be pulled by ICE to get registered. You should be prepared to might have to stay in detention for a day or 2 or 3 as a worst case scenario. You should be prepared to wear warm clothes, bring your medication, to bring any key documents. You should be prepared to make a bond request if you are pulled by ICE, meaning without your spouse, you will suffer extreme hardship. So you should prepare all of those on top of your normal interview. We made a separate video just talking about that. I just went to the AILA conference. We talked with a lot of different attorneys, and that's the advice and that's the official strategy, and that's what we're telling all of our clients as well. And let me know if any of that doesn't make sense. You want to have further questions, I can explain more.
What questions did your 30-year-old client who recovered his CSPA spot get in their interview?
Okay, we have a lot of these, but for the CSPA interviews, they mostly 99% focus on a normal interview 45 questions, right? So just because it's CSPA, just because it's 245I, just because it's anything else, the basis for filing the 45 is not actually the main point. The 45 interview is still a 45 interview. So criminal record, where do you live, where do you work, what do you do, are you lawful stay in the U.S., do you have H-1B, do you have B-1, B-2, right? Explaining everything is still 98, 99%. For the 30-year-old, I mean, we have so many of these, none of them really have told me that they were extremely challenged on the CSPA calculation. And my guess is that most officers don't actually want to care to learn about it. But that's my opinion.
My dad's TPS is coming to an end soon. Can you talk about what a deferred action and if he'd be eligible?
We don't do enough TPSs to be able to advise on that. I'm really sorry. I just don't know. But I'm sure there are really good TPS attorneys that can help you.
Should I be worried? I have not heard back. November 2024. Parentheses MIL space PIP and I-130 December 2024.
If it's a year in process, maybe you would want to check with the service center, the field office, to see if there's anything missing. Because I know every single service center adjudicating their parole in place applications, they do it slightly different. And I know it's extremely, extremely annoying. But I have seen a lot of these cases over the years where one service center wanted a written affidavit of explain everything, another one didn't. And because they didn't have what they quote unquote wanted, it was just pausing in place and nobody was touching it. And the moment you get it clarified, the case was immediately approved. So go to your local field office, do the info pass, and check, hey, is there anything that I'm missing that's needed? And maybe you'll be able to get some answers.
I am a DACA recipient thinking of doing an E2B perm process. Is it too risky to do it with this administration?
No. EB2 perm, it's not necessarily dependent on the administration because the perm process first is with the Department of Labor, and then the immigration law plus the Department of Labor. What affects the case most is actually the unemployment rate. So now unemployment rate is what, 4%, a little bit higher, 5% maybe, and depends on where you live. Depending on where you live, that it has much higher impact of your EB2 perm than anything else. If that unemployment rate goes to 6, 7, 8%, if we hit a recession, then it's almost very low chance that your EB2 will get approved. So if you're talking about, chance of success, this might be the best chance of success.
As a DACA who overstayed with a I-94, I was 2. Can I be detained now that I've submitted my adjustment of status?
Oh, sorry, can you say that question again?
As a DACA who overstayed with a I-94, parentheses, I was 2.
Yeah.
Can I be detained now that I've submitted my adjustment of status?
Oh, because you have DACA, the chance of you being detained is much smaller. The answer to the DACA question is you should be fine, but don't flaunt your DACA status as a means to shut the officers up, right? Don't say like, you can't talk to me, you can't detain me. I have status here. I'm just like a U.S. citizen. I have DACA. They will probably abuse you if you use that line of reasoning. DACA is a deferred deportation essentially. So it's more so like, well, I'm on standby, right? Deport other people first. Don't deport me right now, right? And since you apply for adjustment status, you have double protection. But you should be fine. You should be fine, right? So a lot of the people that we represent who have DACA, who have filed adjustment status, even in this administration, at least you're still very much shielded compared to those who don't.
T visa denied, appealed denied. I refiled, and USCIS is reusing biometrics. Is this a good sign?
It is a 1% good sign, but largely irrelevant. Biometrics is a very much standard process, but we have seen some people, cases, they don't reuse the biometrics and they don't even reissue and then just directly go and deport them. So that's a really bad sign. But I would not think of it like, oh, my case is going to get approved now.
Can you still renew driver's license if they revoke work cards in Texas?
I don't know. That depends on the Texas DMV, and that's state by state. I'm in California. I know in California we do, but I don't know about Texas.
Can you adjust your status if your wife is on housing assistance and SNAP?
Can you what? Renew your green card?
Can you adjust your status?
Oh, adjust status. Based on the public charge rule that's going to be implemented, the 2025 version, the one that they just released and they're receiving comments, the new public charge rule will likely make it significantly more difficult for you to adjust that status. So that's something to really, really think about. And we made a separate video on this. I went really in depth on how to overcome it. So please take a look at that. But just based on your questions, if your dependents are using government benefits, based on new public charge rule, the chance that the government might deny your adjustment status, saying you're inadmissible because of the public charge, suddenly just shot up.
Is detained marriage visa overstay happening all over, or is it just California for now?
We just started seeing it in San Diego, and we are hearing reports of it. We haven't confirmed that, like LA and Santa Ana and different places. I haven't seen it across the US yet, but again, this is very, very new.
Are bail bonds actually being approved?
Yes.
And the same person who asked the earlier question about his parents and he's in the military followed up with, can it help my parents' case if we're working with someone who posed as a lawyer, he lied to us and isn't actually a lawyer?
Matter Lozetta doesn't help you because it has to be a lawyer who's at fault. If somehow your application had an error in it, and that's the reason why your case was somehow denied because somebody fraudulently filled out information incorrectly and it is not your intent. And I'll just give you an example. If on the application they said you entered without inspection, or they said that you claim to be a U.S. citizen that you didn't, and then they used somebody else's application or just brought it over. It is not you, it is somebody else. It's a mistaken identity. You can file a complaint. You can file to prove your innocence. So hopefully that helps, but it's much harder because they are not an attorney.
Do you know how long the N-400 applications are taking to process right now? I'm waiting on my husband's.
I would say around 6 months.
I was brought to the United States as a baby, and now me and my partner are deciding to get married. Could I get deported?
Yes, if the conditions are met. So hopefully you will be able to still get a green card, but there's a lot of things to talk about, right? Whether or not you have DACA, whether or not you have lawful entry, whether you got an advanced parole to be able to come in. Is he able to petition you? Just because he's a U.S. citizen doesn't mean he will petition anybody. And so there's a lot of things to kind of analyze to be able to get your green card. And based on this administration, if you don't have DACA, if you don't have lawful entry, if he's not able to petition you, if there's criminal records involved, etc., yes, of course, you could still get deported.
If you have DACA, can you get married? Would they take it away from you if you get married?
They won't take away your DACA unless you don't qualify for DACA anymore, right? So, but just because you file for adjustment of status doesn't mean you automatically lose your DACA.
With I-94 good until September 2026, can I be detained or deported? I'm applying for adjustment of status soon.
Right. So that's what we're seeing now. If you file for adjustment of status while your I-94 is still in effect, good for you. But then once the adjustment status interview comes, and if you're already I-94 have expired, to them you're a visa overstay. And in that instance, they might pull you in registration, NTA, and worst case scenario, even detention for a few days.
Does adjustment include applying for citizenship? There were Medicaid services I used during COVID.
Adjustment of status does not include citizenship. You usually adjust status to get a green card, and after 5 years, you get a citizenship. And in both instances, adjustment status and N-400, they look at public charge, they look at your entire financial history. And part of that, with the new public charge rule, is looking at, did you use any benefits? And if you did, explain, and how do you overcome that in the future you will not use benefits again. That's a key point. A lot of it is forward-looking. So what is your future job prospect? How much did you save up? Did you invest in Bitcoin that went to the moon and now you have great assets that you can prove? Well, I used some government benefits for COVID, but now I'm super wealthy, right? So this is not financial advice, by the way, right? But it's forward-looking.
I am a U.S. citizen, but my 2-year-old son is in the Philippines. How can I bring him here?
You are a U.S. citizen, but your 2-year-old son is overseas.
Mm-hmm.
So you can file the I-130, right? And then once that gets approved, then you could go through the traditional NVC consulate process, and then they get their green card visa at the consulate in Philippines in Manila, and then they fly over here and they get the green card. So you start with the I-130, then the NVC, National Visa Center, then the consulate.
Can it be safe for re-entry by AP to home country to non-main applicant asylum?
There's a lot of things there. We don't do asylum cases, so I just want to start with that. But even if you did asylum cases and you apply for advanced parole and then you leave the country, as long as you're doing what you're supposed to be doing, how you apply for advanced parole and you're coming back should be fine. You might have to pay that $1,000 fee. You know, look that up. CBPs are collecting new $1,000 fees for everybody who apply for advanced parole, other than a few exceptions. But to the best of my knowledge, CBP officers around the country are not super hard on advanced parole unless there's some clear indication that you're abusing the system. For example, if you apply for asylum and you're the main applicant and then you go back to your home country, they really don't like that. If you apply for advanced parole and then you leave, you go to Mexico and come back one day, you're clearly just trying to take advantage of the DACA adjustment of status loophole, right? And so as long as you have a good preparation and how to present it to the customs officer, it should be fine.
Should I renew my I-94 before expired while waiting for adjustment of status?
Yes, but that depends on how you can renew your I-94, right? So if you're H and L, you can leave the country and come back in. If you're in other types of status, you could change and extend your status. But for some people, renewing and getting a new I-94 is quite difficult.
Someone detained with ICE, how can we find them? How can we ask for a bond?
Yeah, there's the relative tracker that ICE puts out. So use that system. That's the only way, unfortunately. So put in their name and hopefully ICE, and keep on doing it. If they just recently got detained today, yesterday, it takes a few days sometimes before they get logged in. So there's that tracker. The second thing is once you find their location, the relatives / their attorneys can go to the location and try to get an ICE bond. So ICE can let them out based on their discretion. Now, some people have mandatory detention, so sorry, they won't let them out no matter what. But then even with mandatory detention, you can try to apply for bond with the court, but that might take 2 weeks or even a couple months. And then at the bond hearing, if you could prove your case and the judge lets them out, great, right? So start with ICE, and then if they deny it, then go to the court. Yeah.
Can I expedite my marriage-based EAD via congressman and senator simultaneously? It's been 6 months.
In my experience and from talking to a lot of people, it is probably a lost cause. It might take you more time before getting the EAD. We have seen cases where it took 7 months, 8 months, 9 months, but the green card was just directly approved. So maybe them taking longer on a EAD card is a good sign that your green card might be coming faster. Fingers crossed. Yeah.
The viewer who submitted a question for his parents' case and is in the military said, thank you, and he will book a consultation.
Thank you.
I have IND court hearing in December. Will new USCIS policy affect my hearing? I am from Turkmenistan.
Oh. Best case scenario, you can kick the immigration hearing back by another half a year or a year and maintain status, hopefully. Worst case scenario, they do expedite removal, which I really hope doesn't happen. So if you're part of those 19 countries, their immigration courts, USCIS, everybody is stopping these. You might actually just get a notification, a day prior, 2 days prior to the interview, saying that the interview got moved and got paused. So let's see what happens.
A viewer commented, I got I-94 through military parole in place.
Yeah, congrats.
Waiting on my stepson, 12, filed I-130 in March. Mom is here in Florida. USCIS says 17 more months. Is this accurate?
Take the USCIS time with a grain of salt, right? They don't trust it. We don't trust it. It's a system thing. It might be a little bit faster. It might be a little slower. But definitely don't bank on that amount of time.
Not sure if you have seen EAD length cut from 5 years to 18 months just now. Breaking news.
Oh, wow. Yeah.
The viewer from Turkmenistan commented it's a court hearing.
I see. So I know USCIS are pausing everything, but so the court hearing might get pushed, right? Today's success story is about an H-1B transferring to a new company and then getting a green card. Right now, it is a very difficult time for a lot of people who are on their H-1B. Why? Because a lot of people are getting laid off. It is very difficult to apply to renew a H-1B. And if you leave the country and a new employer petitions for you, you might have to pay that $100,000 fee. It is a very, very stressful time for anybody on H-1B, especially November, December, where there's a lot of layoffs that are about to happen, that are happening, and you have that grace period. Even if you have an I-140 approved, sorry, if you don't have an H-1B transfer, you still have to leave the country. And if you file a new H-1B and you want to come sooner, you still have to pay that $100,000 fee, right? A lot of people's H-1B is going to be used up 5 years, 6 years, 7 years. Sorry, your H-1B is out of luck. But if you have that I-140 approved, if you don't have a new employer, it still doesn't work. This is a story about that situation. The client was laid off by this flooring company, okay? She's an operation analyst at a flooring company, pretty big company, got laid off. Very stressful situation. The competitor of this flooring company really liked her and wanted to hire her. I mean, I'm sure they talked a lot and retained us to file for this petition. It was quite complicated because the H-1B was almost used up. There was like half a year left because she was already on H-1B for a long time. The prior company filed the I-140 but didn't want to continue to keep her. So here are the steps that we had to do. The first, this year, we filed the H-1B transfer. Smooth, no problem, because she had the H-1B for so long. She's capable. The new company, similar company, right? Flooring companies, operation analyst. We filed the H-1B transfer, brought her over very quickly during that transition time. Then second, immediately filed the perm application. And once, it took 2 years for the entire perm application to go through, labor certification, perm, that entire process. Once all that was cleared, we were able to file the 45 and the I-140 concurrently because we were able to reuse the prior company's I-140 approval. This was so important because if we didn't do that, then her H-1B would be out, right? But because we're able to file the 45, now we can continue to extend that H-1B for that period of time. She was rushing it down to the very, very last second. My advice to anybody who's stuck in this situation, they have an H-1B or they have an I-140 and H-1B and they are laid off and they have this grace period, look for competitors. Look for a smaller company, a smaller company. They might not have the ideal job. They might have the job position. They might not have the ideal salary and benefits. But if you go to a competitor, it makes the H-1B transfer process that much easier, right? Especially if it's in the same role. We encountered that problem. The problem you probably will encounter is that the second job is not able to afford your salary. The ability to pay is a high risk issue. And that happened in this case too. The second company, the second flooring company, they didn't have, the H-1B pay wasn't as high as the I-140 prior approval. The H-1B pay wasn't as high as the prior H-1B. And their net proceeds, their company wasn't as wealthy, didn't have as high revenue as the prior company. It's a competitor, but it's smaller. And that's one reason why they can't afford as much, right? And anybody who's being laid off now when they're going to a competitor, probably very similar situation. Your salary was higher and now it's dropping. Your I-140 prior approval was higher and now if they're only able to offer even a lower salary, now you have to make up for that difference. So one of the things you have to do when you talk to your new employer, when you're working with a new employer, is to see, well, can we make any sort of argument that with your additional assistance and the company, the new company that's petitioning for you is on its way up? The business plan, the market share, the investment, the stock price, anything that can show that the company have the ability to pay for that additional difference. Let's throw out some numbers. Let's say your original I-140 or your original H-1B was like $80,000, $90,000 or more, and then your new salary is $70,000. Okay, now there's a $20,000 difference. In our case, it was a $7,000 difference. We need to go through the entire company's business plan and argue, look, with the company's growth in the past couple of years, they will be able to make up for that little bit of a difference, that they will be able to pay, even though their tax returns might not be able to show it. Maybe but based on their marketing campaign, based on the number of employees that they've hired 4 additional new employees in the past year. Of course, they can hire 1 additional employee that covers the $7,000 difference, right? So that's something that you will have to do. Maybe most people don't know that, are not accustomed to that. They think H-1B and perm purely is just based on my resume, my education, my job duty, and the company's role and the wage determination and the lottery. There's actually the ability to pay issue, which we see a lot of denials on. So if you're in a situation where you feel like you're stuck to a company or you got laid off by a company, you have a very short amount of time, the highest rate of success to find peace and to maintain your status. Find a competitor, albeit a smaller one, that can give you the same position, similar position as much as possible. Do the H-1B transfer. You have a prior I-140, you reuse that priority date, and then if it's current, then you can file I-140 and 45. In our case, everything got approved, and the green card is here. That just happened. When did that happen? Let me see. That just happened last month. And so this was, we started it last year. We did the H-1B transfer, we did the perm, we did the concurrent I-140 and 45 approval filing. And so hopefully that kind of gives you the guidance, because a lot of people are stuck in this situation right now. Now, with a little bit of time left, I'll answer some more questions before we close out the live session. Thank you guys. Take care. Bye-bye.